All right, hi everybody. Thank you for joining us today. We're going to be discussing preventing modern slavery and the obligations on your business. By way of introduction, my name is James True. I'm a practice leader in LegalVision's employment team, and I'm here joined by Jo Chen. She's a lawyer in our regulatory and commercial contracts team. Modern slavery issues, they cross two areas. Employment in the sense that it's often tied up with employment conditions, as you can imagine concepts of slavery would be. But it's also very much an issue for the commercial arm of your business. Consider how it's going to take steps to address modern slavery and comply with the various obligations under the law. So for that reason, you have an employment lawyer and a commercial lawyer here with you today. In terms of what we are going to be discussing, I'll run you through today's agenda. So we'll provide you with an overview of the modern slavery framework. Next, we'll be determining if you are a reporting entity, so whether this actually covers you. If it does, or if you've chosen to comply voluntarily, next will be, well, what are your obligations under the legislation? We'll run you through modern slavery statements, which is a key part of your obligation. What happens if you don't comply? So what's at stake here? And then some tools for compliance, how you might set up a framework for ongoing compliance with this legislation, because it's certainly something that is here to stay. After that, we'll take your questions, so please feel free to shoot through your questions during, and we'll try and get to as many of them as we can at the end. And then finally, we're just going to touch on LegalVision's desk extension product briefly, which is just one of the various products we offer here, but we think might be suitable for a lot of those who are joining us today. So I'll hand over to Jo, and Jo, if you can maybe provide us with an overview of the modern slavery framework.
Yeah, for sure. Thanks, James. Hi, everyone. So look, by way of kind of a helicopter overview, the Modern Slavery Act came into force in January 2019 and effectively established Australia's national modern slavery reporting requirements. The Act is kind of intended to kind of capture serious instances of modern slavery and kind of goes into define what that means. So it speaks to including kind of 8 specific forms of serious exploitation, which includes trafficking in persons, slavery, servitude, forced marriage, forced labour, debt bondage, deceptive recruiting for labour services, and really the worst forms of child labour. Now, that definition is really only used, and the regime's really intended to capture those serious instances of serious exploitation, and isn't necessarily intended to kind of capture practices like substandard working conditions or underpayment of workers specifically, really unless those practices are particularly serious, in which case they can certainly kind of turn into modern slavery if not properly addressed. But by and large, this regime is seeking to encourage big organisations with ample resources, really, to take the lead in the business sector and seeks to establish kind of a continuous year-on-year improvement regime to really tackle the issue of modern slavery within Australian businesses. It's worth quickly noting that today we're kind of speaking to the Commonwealth regime specifically. For those of you joining from New South Wales, there is a New South Wales Act. It's not yet in force necessarily, and the nuts and bolts are still being finalised, which is something that James is going to touch on a little bit later. But for now, perhaps, James, it might be useful if you can run through how entities can determine if they're captured and determine if they're reporting entities.
Sure. So when we look at that, really, I guess there are 3 considerations, as Jo mentioned. There's Commonwealth legislation, which we'll talk about whether you're a reporting entity under that legislation. We'll touch briefly on the New South Wales legislation, although it's not in force, but it may be in the future. And then also, of course, this can still be very relevant. A lot of organisations are choosing to comply with these obligations on a voluntary basis. So even though you may not meet the technical definition of a reporting entity, you're nonetheless going to comply. So under the Commonwealth legislation, you're a reporting entity if you're an Australian entity or you carry on business in Australia and you have a minimum annual consolidated revenue of 100 million. Okay, so we'll break that down and work through those key definitions. So an entity, individuals, partnerships, associations, it's extremely broad. Companies, trusts, super funds, and other types of investment organizations. So very, very broad, everything's an entity. It also covers your commercial entities and then also your not-for-profits. So that's pretty clear. The reporting period, which is relevant for your consolidated revenue, is your financial year or some other accounting period. It usually is your financial year. Consolidated revenue. So this is the $100 million mark. Basically is the total revenue of the entity, but if that entity also controls other entities, then it's going to include the total revenue of all the group. So that concept of consolidated revenue and then also that concept of control really determined by reference to Australian accounting standards. If this is something that you're close to the mark and the question of compliance for your business is critical, then obviously there's a pretty potentially complicated or certainly detailed piece of work there to be done in considering whether you meet that consolidated revenue threshold. And that final aspect, Australian entity or you're carrying on business in Australia, again, relatively broad, an entity that's a resident in Australia for income tax purposes, if you're incorporated in Australia, or otherwise if central management and control is in Australia. So again, for some entities, pretty clear cut. For others, and as I said, where the considerations of the actual application of this legislation is really critical, then again, there's always potentially at least some semi-complicated work that you may like to take to really understand whether you're doing this on a voluntary basis or whether it's required. I'll just touch briefly on New South Wales. And again, as Joe mentioned, so New South Wales actually was first off the rank with introducing a Modern Slavery Act that was passed in June 2018. It is yet to commence, and there's certainly a unique feature about that legislation. Ordinarily, legislation is passed, it commences shortly after, or otherwise it commences on a date which is actually prescribed in the legislation, so everyone knows when it is going to commence. Commencement in relation to this act is just up in the air at the moment, and for the most part, it is on hold while the state government and federal government, and then the other state governments around the country are ultimately figuring out whether there will be some kind of process of harmonisation between the Commonwealth and the New South Wales regime. So it's really up in the air. We're not really sure when or frankly if at all it will come into force, but it has been passed by Parliament, so we would expect that in principle there is support for it in New South Wales. The key difference is that in New South Wales the turnover threshold is lower. So it's going to apply to a commercial organisation with $50 to $100 million turnover. The obligation under that act will be that those entities will have to submit a statement with the Anti-Slavery Commissioner of New South Wales. And critically, under the New South Wales Act, there are penalties of up to $1.1 million for failure to comply. That is in what is a very large distinction with the Commonwealth Act, which we will deal with consequences for non-compliance under the Commonwealth Act, but a bit of a spoiler alert, there are no penalties. So the New South Wales Act and what comes of it will be something that is really kind of a watch this space. and we'll keep you updated as we find out any kind of updates on that. So we will continue dealing here for the purpose of today with the Commonwealth legislation, because that's what's in force. And it's probably a good time to hand over to Joe. Joe, perhaps you can walk us through then what are the obligations under that legislation?
Yeah, for sure. Thanks, James. So look, the upshot really is the key obligation under this regime, simply put, is reporting. So reporting entities need to submit an annual non-slavery statement to the non-slavery register, which is run by the Australian Border Force. This is a public statement of this is a public register, sorry, of statements. So you can really go on there and search for any submitted statements, search for your favourite brands, and have a look at what they've submitted. And what I suppose we'll largely be talking about for the rest of this presentation is really what sits behind that reporting obligation and how you can kind of get there. Importantly, I suppose to understand is really what is a modern slavery statement? What does the legislation kind of consider to be a modern slavery statement? And there are 7 mandatory criteria that need to be included in a modern slavery statement. So at a real kind of helicopter view, the first criteria is identify the reporting entity. Now, again, as James touched on, there are thresholds to consider. This generally sounds pretty easy, but can get a little bit more complicated when you've got group companies or international companies to really figure out who is your Australian reporting entity for the purposes of this regime. The second mandatory criteria is to describe the reporting entity's structure, operations, and supply chain. To then describe the risks of modern slavery practices in those operations and supply chains, which includes kind of any relevant entities that reporting entity owns or controls. Describe the actions taken by the reporting entity to assess and address those risks, which includes due diligence and remediation processes that might have occurred. Describe how the reporting entity assesses the effectiveness of these actions, so kind of a reflection point, which really speaks to that year-on-year continuous improvement regime. And then describe the process of consultation with any other entities the reporting entity kind of controls or owns, or any third parties. So this a lot of the times will speak to whether an Australian entity or Australian sub is speaking to global HQ in preparing a statement or a joint statement. And then the 7th catch-all mandatory criteria, provide any other relevant information. So in this last reporting year, unsurprisingly, we've seen a lot of reporting entities use that as an opportunity to speak to the impacts of COVID-19, whether that had impacts on their workforce, their resourcing, their supply chains, or reasons why they weren't able to do as many of the modern slavery compliance activities that they may have wanted to. That's really your opportunity to put anything else in there, essentially that you want the public to know about your modern slavery compliance. Importantly, the Act also requires that the statement itself has been approved by the principal governing body of that reporting entity, and is subsequently signed by a responsible member of that principal governing body of the reporting entity. So generally that looks like your chairman of the board, a director, or a CEO, but it is a strict requirement that you have in there that it has been formally approved by that governing body. The requirement then is quite simple. The statement needs to be submitted annually to the publicly available Australian Border Force Modern Slavery Statements Register within 6 months after the end of your reporting period. And now the process to do that is pretty straightforward. You go onto the register, you click submit, there's a form, and it's relatively straightforward. So look, from here, it's probably a good point, James, if you wanted to speak to kind of the impacts of non-compliance and what happens perhaps if you don't submit a statement.
Sure, thanks, Joe. And look, as I mentioned earlier when we're talking about the Commonwealth Act, non-compliance, certainly in any financial penalty sense, there are no penalties under the Commonwealth Act. Your one obligation under that legislation is to submit the statement, and as long as the statement is in the form that Joe has just talked about, you're going to comply. Now, if you don't submit the statement, or the statement is not in the right form, there's no penalty, there's no strict enforcement of that obligation. What you may see, and what Border Force, which is the organisation which is responsible for administering this legislation and enforcing it, they can name and shame, and that's really about the extent of it when we're looking at, what kind of heat can you come under from the department. The intention of this legislation when they brought it about, and there are obviously various ways when legislation is brought in that governments incentivise compliance with that legislation, and usually it's just penalties for non-compliance. In this instance, the legislation is created on a basis that compliance is a race to the top. And that's certainly in all the explanatory memoranda or all the commentary around the legislation as it was being brought in, just trying to create an obligation here to create the statement, but then leave it to businesses to ultimately compete with one another to, I guess, for a sort of ultimately on a bit of a marketing perspective, and I guess a genuine compliance / goodwill type consideration, actually go and take these steps to combat modern slavery, and that competition between all these private entities would ultimately bring about a better and sort of more wholesome, I suppose, or genuine reduction in modern slavery. With that in mind then, I want to just show you two examples of statements and what compliance might look like for you. So if we just click through, there we go. Each of these statements is totally compliant. And what you have from Woolworths on the left there is a very nicely prepared with a lot of effort put into a heap of graphic design and 32 pages of it, detailing their statement and all the things they've done in relation to modern slavery and an assessment of the effectiveness of those measures. This is very much intended to be a public-facing document. It'll live on their website, and so exactly in a sense what the department is looking for when they set about this regime, to look for businesses to really go hard at combating modern slavery. By contrast, you've got Breville on the right there. Now, perfectly compliant statement, that needs to be really clear, that they've absolutely complied with the Act, and not really making any comment here on whether they're doing more or less than Woolworths in relation to modern slavery at all. But you can comply with this Act by submitting a 4-page, black and white Word document that absolutely complies with your requirements. These statements speak to what each entity is doing, and I guess, Joe, I want to hand over to you then to talk about that framework. So you mentioned then that the framework sits behind the statement, and so if you're going to create a statement, that looks good, or that covers off some real genuine attempts in your business to have complied or to have combated modern slavery, what should a framework look like, and how do you go about doing it?
Thanks, James. Yeah, for sure. So look, I suppose the point flowing on from James there is that what compliance looks like specifically as an organisation isn't prescribed by legislation. So really the substance of your statement isn't what is necessarily scrutinised by the regulator itself. They're not going to stop you from submitting a statement unless it's not signed off by the board. But they're not going to say this one's better than the other. What that means is that actual compliance for you and what your statement looks like, and effectively the things that you as a business are doing and how you want to say you're complying and addressing modern slavery is really up to the business. A way to really, a good starting point to kick all of that off, I suppose, is to work backwards from the statement and have a think about the 7 mandatory criteria that they are asking you to speak to. And crucially, the part that takes the most work for organisations really is to identify the risks of modern slavery. So how are we saying that we're identifying risks in your supply chain? What are you doing to address and mitigate those risks on quite a structural and ongoing basis? And then that reflection point, how effective have any of those activities or actions been in that given reporting year? So really a big part of the overall compliance challenge will be, how are you planning for that year-on-year reporting, and how are you making it easier for yourself to kind of generate and create and submit a statement every year. So to do that at these kind of early stages, as James mentioned, it's really useful from our perspective to prepare a compliance roadmap, essentially, that looks at the wider picture of continuous improvement, such that, again, you have annual action items that you can implement and you can report on. And you know, the regime itself isn't intended to be everyone fix modern slavery in the next 2 years or we're going to come after you. That compliance framework can be whatever you like. It's meant to be ongoing. It's meant to be a long-term structural thing that helps shape the business, really. And from an organizational perspective, really, the more organized that you can be about it, as I said, the easier it's going to be to annually prepare and submit that statement. So look, a good starting point is to know your business, of course, to get a sense of your supply chains, and really, if it's the first or second year, to get your house in order. And to do that, you really need to identify your internal stakeholders that are going to have input into that statement, and are going to assist with rolling out initiatives or trainings and things like that. And usually we see that be a stakeholder in procurement, because they're going to understand your supply chains the best. Someone from marketing, usually, because they're going to know what your corporate voice is and how you want the statement to look from a branding perspective. And of course, legal, to ensure that the mandatory legal requirements are satisfied in that statement. It's also useful, to understand and have a basic understanding as well of what is considered to be high risk locations, industries, products and services in modern slavery, so that you can really drive those high risk areas that you need to focus on. And the guidance and the explanation from the Commonwealth Government is that they expect organisations to take a prioritised risk-based approach to that, and in order to do that, you have to have some understanding of which kind of areas, locations, industries are considered to be high risk more generally. And finally, really, one of the most obvious things, but one that we don't see as often as we'd like, is to record your actions. The worst thing is when an entity is doing a lot in the space but hasn't properly documented it, or not one person has kind of kept a record of what's been done, and that makes the fact-finding element of preparing a statement kind of that much harder. And so if you can kind of front end that, put something in place, and have a think about how you're recording all of those actions, again, when that reporting deadline comes up, it makes it a lot easier for you to pick up and go and draft that statement. So to turn to, I suppose, some useful and practical tools for compliance that we would see, as mentioned, it's useful to work backwards from those mandatory elements of the statement, which is what we'll do here. So the criteria describe the reporting entity, structure, operations, and supply chains. So a few things you can do to help you be able to answer that, as I mentioned, is have a think about an internal stakeholder kind of business questionnaire to be able to get all the relevant info from within your business first. That's kind of the getting your house in order side of it. Know who knows things about modern slavery, who's already doing stuff, who can be involved, and get a good sense of where the business is at more generally in relation to modern slavery. And then have a think about supplier mapping. So it's useful to understand your business internally, and then to understand your supply chains a little bit, to understand how big a task this is. Do you have a sense of who your top 20 suppliers are by spend, or how many you've got? And that'll kind of give you a sense of by and large how big the job is, really. The next criteria, how are you identifying the risks of modern slavery practices in your operations and supply chains? So for that, some tools that kind of help with that is to conduct supplier due diligence and screening. So how are you ensuring that the suppliers that you onboard and use are live to the issue of modern slavery? And then to undertake kind of targeted supplier risk analysis to determine what areas or what suppliers or what parts of your business might be high risk. Again, the regime is intended such that you can take that prioritized risk-based approach. You don't have to solve it all in one statement. Pardon me, but is for you to be able to identify, you know, in the next 5 years, we want to target these areas because we have determined those to be high risk. Next, how are you assessing and addressing those risks? So this is where we see probably the most movement and the most kind of tools from a documentation point of view. So contract clauses and supplier warranties in your supply agreement. So turn your mind to whether your supply agreements have contractual clauses that speak to non-slavery compliance. Implementing things like supplier code of conducts and site audits of your suppliers really helps to establish from the get-go with your suppliers what your expectation of them is in relation to non-slavery compliance. Things like staff training, of course, are really useful as well internally so that people in the business know how to address non-slavery and in turn know what to do if they suspect or know that there are instances of non-slavery within the supply chain, but also to think about expanding that and extending it to your suppliers and training suppliers about your expectations as well. And then really ultimately is to look to establish an internal framework. So look to having internal reporting mechanisms and things like anti-slavery policies such that, again, the business is informed, people are trained, and there's clear responsibility and clear reporting lines to address those non-slavery risks that have been identified. Then how do you assess the effectiveness of any actions taken? So this is more that reflection point. Again, track engagement, track the actions that you've taken across the business and establish that as part of your internal review process. So year on year, you're going to have action items that you want to hit and be able to report on. And a part of that should also be a reflection on the previous year. And to do that, it's useful to have a think about what KPIs you're going to use to measure that. A lot of people, you know, use how many reports they receive from internal reporting lines or other reporting channels, how many suppliers they can onboard into a supplier code of conduct, how many people they've trained. And all of these actions and this reflection point will become more important in years to come. So it's hard to kind of say in the first couple of years, but, you know, in 10 years, this particular criteria will be important for you to be able to say, well, we implemented a supplier code of conduct in year one. This is how we think that's working or not working, and to have a think about what you're using to measure that. And then to go beyond that as well, to have a think about working with your suppliers directly or your top suppliers or the ones you've identified as high risk, and share that reflection point with them and speak to them about how to improve the process more generally. And then to have a think about engaging third parties or building partnerships, engaging with civil rights groups or other third parties that can help to undertake more of an independent review of the business to see how it's going, to see how effective all the actions are, to enable you to kind of report on that year on year. So I think that was me for the tools for compliance. I do know that we have prepared a fact sheet to that end, which sets out kind of all of these points, which is available to download. There it is. You can download the fact sheet, which kind of speaks to all that, what the statement is, and the tools for compliance, which is available in the handout section of the webinar panel. I think from there, James, it might be time for questions.
Yeah, for questions. Thank you, Jo. And thanks everyone who has submitted a question. I think we'll try and get to as many as we can now. And I just want to raise too that if we don't get to it, or if my answer to your question is I don't know, then feel free to, you can reach out to us. There'll be an opportunity to contact us afterwards. I'm going to speak to that in a little bit. And so if there's something you want us, we can just take a little bit more of a look at or have a chat to you about it after this. If we can't kind of handle it on the spot here, then definitely we're happy to do that. Question number 1 here is, as a small business with enterprise clients, we're sometimes asked about our modern slavery policy. So do we need to create a policy to satisfy client requests, or can we advise those clients that we have not yet addressed this? That's a great question, because that comes up a lot. You know, what we're talking about here today is, well, are you obliged at law to file this statement? Now, if you don't meet that 100 million threshold, then the answer is no. So there's no law requiring you to prepare the statement. But of course, a lot of the clients that you're dealing with will need to file that statement, and one of the steps they will take, and these are the things that Joe's just been talking about, one of the steps that they'll take is requiring that anyone they deal with has some kind of policy in place, or is, you know, has its own procedures in relation to eliminating modern slavery. And it's very much the intention of the organisation that this is just going to filter down supply chains as the companies with the obligation and those with that revenue level, they're going to require it of everyone, and that's going to force everyone to comply. So ultimately, it's going to then come down to, I suppose, a contractual obligation. Now, if you've got a client who says, I want this, and if you don't do it, I'm not going to contract with you, well, that may be your answer. You might find too, though, that if you do go back to them and say, look, we don't have a policy, because, you know, to be clear, we're not subject to the legislation. However, we're happy to provide you some guidance, information, some kind of assurance that we have taken some steps in relation to modern slavery in our business. That may be enough for that client to say, okay, well, that satisfies us. They may try and require that you've got a policy, but when they prepare their statement, when they say, well, look, one of the steps we took was we required all of our suppliers or anyone we engaged with in business to have a policy, and then they make an assessment of the effectiveness of that as part of their statement, they might just say, well, it wasn't that effective because not everyone had it, and we were unable to force them to have it. So really, that answer, in short, is it's a question that's going to come down to the relationship between you and the client. You know, if it's good enough and they like you enough that they'll still be happy to proceed even if you haven't got it, then great. And if not, you may need to put the policy in place. Unfortunately, for a lot of those companies, there are elements of this which are a box ticking exercise. And that they just want to make sure that they can say they've done the right thing by shifting it on to you. So you may consider then whether, you know, for the purpose of satisfying their box ticking exercise, you do actually go and prepare a policy yourself. It doesn't necessarily need to be the world's most complicated or detailed policy, just what's going to be enough to satisfy that client. All right. The other questions we've got, let me just scroll down. Okay. What advice would you give to preparing a consolidated modern slavery statement covering the Australian and other international regimes? Good question. This comes up a lot, particularly because the UK is a couple of years ahead of Australia in relation to modern slavery. Ultimately, for that Australian entity, it's going to have its own obligation to file a report which covers those aspects of the legislation in Australia. And so, sorry, a statement rather than a report. It's going to have to file its statement, and that statement's got to comply. Where and I guess a lot of this depends too on how distinct the practices between, say, the UK entity, which is likely ahead of the Australian entity in terms of steps it's taking and compliance regimes. I guess there's a question as to how different those matters are, and whether there is actually any sort of procedural distinction between the steps on the procurement process for the UK entity and the Australian entity. So where the Australian entity has maybe adopted the UK entity's processes, it may only really be a sort of minor tweak on the UK statement to get it into shape for submission in Australia, because the UK statement is already going to have a very significant background on what steps have actually been taken. And they're usually very comprehensive over in the UK. So yeah, look, still going to have that obligation in Australia to submit a statement that complies with Australia. But I think you'll find a lot of the work has been done by the UK entity anyway, so you can probably adopt a lot of it. All right. When we talk about the revenue, and frankly, I was dreading questions about the revenue and calculation of the revenue. So is it only downstream control, not upwards? I understand it to be downstream control when we're looking at whether you're considering whether you track the revenue of just your group or all the others. But as I said, that can be a pretty complicated piece that needs to go back and look at accounting standards. And so, look, something potentially have a chat to us about further, but to land on that very clear position, I'd want to spend some time on it. The next question is probably equally complicated, and I'm going to give the same answer, but it's our business has a consolidated revenue of 100 million plus, that 80% of that is excise attached to the goods, and we effectively pay the government that excise directly. So is the excise part of the consolidated revenue, or is it to be justified differently? And unfortunately, sorry, I don't know. And so, yeah, let us take a look at that. Reach out to us and we'll try and work through it. How does our responsibility in our supply chain stop with the companies which provide us with a product or service, or does it extend to the supply chain of those companies as well? Your initial obligation, and you can really go as far as you want, remembering that the obligation under the Act is to prepare a statement which says what you do and make an assessment of how effective those things that you do are in combating modern slavery. I think with that in mind, you absolutely can extend it further, but there may be limitations then on how effective that is, or how easy it is for you to make an assessment of it. So for example, if you were to deal with your supplier, you might ask your supplier to sign up to a code of conduct. You might include in your contracts with that supplier that they warrant to you that they have their own modern slavery regime in place, and that they are taking steps to combat modern slavery in their own supply chain. Whether you choose to audit that business and then require proof of it, it's totally a matter for you. And when you're setting up that compliance framework, obviously, if you want to go the extra step and carry out that audit, you can. You can ask. It's all really how much do you want to require in that contract with your supplier that they do certain things, and do you want to require evidence of it? So you absolutely can, because it's a matter for agreement between you and your supplier. But you don't have to. You can leave it at, all right, well, you're going to warrant that you're doing something about this, and that's good enough for me. And then when you provide your statement, the things that you will say, in terms of what are we doing? Well, one of the various things I imagine will be that we're requiring our suppliers or anyone we're doing business with to tell us that they have a regime themselves. And when you make an assessment of the effectiveness of that, you can say, well, it's a little bit hard to assess that at the moment, because either, we don't audit and we're just kind of taking their word for it. Now, does that create the best looking modern slavery statement in the world? Probably not. But does it comply? Yes. So as I said, it is really a question of how far do you want to take it. How can we check modern slavery risks when dealing with large multinational tech companies? Great question. I don't really know. Is the answer in terms of how we actually make that assessment. Again, there are always going to be limitations on how far you can go. There are lots of different processes, I suppose. Instead of going directly to that organization and either asking them to turn over records or anything like that, which is not likely something they're ever going to provide to you, There are external organisations which do actually provide, you know, so the NGOs, some charities will provide advice or overviews of, particularly in a geographic sense, where modern slavery risk lies. So that can be something that you can look at. In terms of what external resources can you leverage, you know, in terms of understanding, okay, well, where does that client you're dealing with carry on business, and can we go and find one of these NGOs who's providing us with an assessment of, you know, employment standards or modern slavery risk. So there are organisations which are expressly dealing with modern slavery, sort of almost like a modern slavery watchdog in a sense. So you'd be able to go and use their resources to make an assessment. But again, ultimately, there's going to be a limit there on how much you're going to be able to be changing the behaviour of, you know, your large multinational tech company. And again, that's something that you can potentially deal with in your statement in terms of, okay, well, how effective were we in getting Microsoft to amend their terms? Not very effective, and that, you know, and that's a reality for a lot of businesses, you know, in trying to make those changes to your contractual terms with those bigger providers. They're not interested in amendments. So, but yeah, as I said, there's the opportunity to do some research outside of dealing with them directly.
I'll add to that point really quickly, James, sorry for interrupting, is also a lot of the times when I'm doing that, a lot of those big companies are going to have their own modern slavery statements or their version of that, a UK version. US has some similar laws, and a lot of the time I look to those documents as well, and it's useful to have a look at whether some of your suppliers or the big companies have their own modern slavery statements, because again, that can feed into how you're risk assessing them as well as your suppliers. So if it's a big company and you find their modern slavery statement and you have a read through it, you can in turn kind of say, you know, we don't consider them to be a high risk supplier from a modern slavery perspective because of this public statement that they've made. But again, yeah, as James mentioned, how much you can actually get into their actual business procedures and documents is a different matter, but always have a look at what they've kind of published themselves.
Great, thank you, Joe. Yeah, that's a really good point to make. All right, look, I think that's it for questions now. I just wanted to wrap up by touching base on our desk extension product. So that's LegalVision's desk extension product. It's effectively a product we offer. It's really suitable for large businesses or particularly those with an in-house legal team. It comprises a monthly fee that gives our clients access to all our lawyers, and that fee covers all of your business as usual legal work throughout that month. We aim for as few exclusions as possible to what's covered. That means it really is, as best we can make it, all-encompassing. It means you've got certainty of your legal spend, and we can spend less time talking about our fees or hourly rates or the scope of work, all that boring stuff. We spend more time learning about your business and ultimately just getting on with providing you with advice. That advice would certainly include advice on your modern slavery obligations and setting up an ongoing compliance framework. That's something that we would definitely do as part of that product. So look, if you'd like to learn more about that product or any other products we offer, because we certainly don't just cater to those larger organizations, please click yes on the survey that will follow. And I'd also recommend for those of you who had questions that we weren't able to get to or that I didn't know the answer to, click yes and we can have a chat about that as well. But otherwise, thanks so much for joining us today. Thanks for your time. And otherwise, just hope you all stay safe out there. Thank you.
Thanks, everyone.